All right, welcome back. Some more fun on estates and land, which we defined the main ones in the previous capsule, of course, right? We talked about fee simple, we talked about the life estate, both of which are what we call freehold estates. And then we talked about leasehold estates, in contrast to freehold estates, right, where the right that is given remains a property interest in the sense that we've used so far in the term, right? It's not like a license, which is not a property interest. So lease is a property interest. It's a leasehold interest, right? Leasehold estate, because estate means interest, right? These are the main ones. And we also said there's a fee tail, which is also a freehold estate, but which is now prohibited in Canada. Now we'll get into a bit more complexity about that. Because we said, in the previous capsule we said, the grantor, the person giving away their interest, can create successive interests by combining the ones that we looked at in the previous capsule. So, of course, if they give away a fee simple, they've got nothing left, so they can't do that. But they can, right, give a life estate to a person, in which case they retain the right of reversion, which is the right to show up when the person dies, which we said is a present interest. Both of them are present interest because even though you don't know exactly when the person will die, you know for sure that the person will die. Therefore, it's a present interest to future possession because that event will for sure happen. So someone gives away a life estate, right? They keep that right of reversion. They can give it away to someone else, in which case they keep nothing. And then they're combining, right, two things. They can also say to A for life, then to B for life, then to C for life, and then subsequently to a third party, in which case they're combining, right, 3 life estates, which they can because the life estate is temporary, right? They can decide what happens when A dies, and then they can give away the right of reversion, which is another part of their property interest. Of course, for these things to happen, right, at the time they will, you have to see whether the person will be actually alive or not because they only get a right to enjoyment during the period of their life. So I'm starting back at page 220. Most of that we discussed already. Fee simple is of potentially indefinite duration, meaning that it's only subject, as we said in the previous capsule, to the ultimate right of the Crown, because we said there is no such thing as ownership. And if you die without heirs and the government's done looking really hard for people to give your stuff to, and there's no one, it goes to the Crown. And so it's potentially indefinite in that, right, eventually it may go to the Crown. As we said, one important thing about that is that conceptually that does not, right, that does not change the fact that it's a present interest. Because under the conceptual framework, we assume that one day for sure you will die without heirs. But right, in that sense, it's potentially indefinite in the event you never die without heirs. And it's indefinite, right, in the sense that if you do, right, fail to die without heirs, you essentially, though indirectly, keep it forever. So the fee simple is the biggest estate known in law. It's the way in which we usually pass, right, what you've assumed so far was simply called ownership. As we said, it's important to use the magic words. We'll see it's no longer mandatory, but up until 30 years ago, it was crucial to use the magic words, which are to a and is heirs, and that's how you define a fee simple. It wasn't even by using the words fee simple, it was by using the magic words to a and is heirs that you granted the fee simple. And that was really important because if you didn't use these words, right, the court would invalidate the disposition, the transfer, whether that's, right, for free, for money, while you're alive, when you die, whatever it is, right, would invalidate the transfer because you did not use the magic words. As we'll see, that was altered by statute in 1990. Nonetheless, it remains best to use the magic words, as we'll see, because then there's no confusion, right? No one can show up to court and say, you didn't do it right and therefore it's invalid even with the statute. Traditionally, I'm still at 220, you had 3 rights, right, under Roman law, which are still true today. Again, because you have, to the extent that you have a fee simple, you have essentially all of the rights in your land except that very limited possibility that one day you will die and the crown will get it because they can't find heirs. And the 3 rights are the use, the fruits, and the abuse. The use meaning essentially possession. By virtue of a fee simple, you have the right to possession of your land. The fruits meaning you have the right to profit from your land, whether that's by, say, farming and selling the crops, or whether that's by, right, giving your interest to possession to someone else in exchange for money, which again we call generally a leasehold estate. And the right to abuse was simply the ability to basically break up your land, right, such as by mining or other similar things. Of course, that might be, again, regulated by statute. Today, it's not that simple, right? You don't get the mining rights automatically. To the extent that it's not altered by statute, by virtue of the common law, you have that right. That implies, even though it's not in the list, that you have a full right of alienation, again, because you have something that you've been mistaken as full ownership. So you have a right to freely dispose of your interest, in other words, to transfer it to anyone for free, for money, when you die, before you die, whatever it is. And you have a right, of course, as we said, to create lesser estates. There's also mentioned, page 221, you can create other kinds of property interest, which we discussed briefly, which we'll get back to, which are smaller than a life estate, because a life estate is pretty expensive. It lasts for the entire life of the person, and it gives them the right to exclusive full possession to the exclusion of the owner for the duration of their life, right? The owner or whoever has the right of reversion. You can also create other kinds of property interests, which we talked about briefly again, and which we'll get back to, which is everything but a license, because a license is not a property interest, and that includes an easement, a covenant, an easement being a right, a covenant being an engagement not to do something usually, or a profit de prendre, which is a right of a person to enter upon your land to take stuff. And it's not a license because it's more extensive. Usually it's not right once, it's a repeated thing. And you'll recall there was a lady in the case from last week who had a right of way. So she had a right to cross her neighbor's land, right? And we see that in other cases in the law, such as when you have people whose land is enclosed. I think that's the example we gave, right? So if you don't have access to the street, you're kind of stuck there, which is a problem. So the government's going to give you a right to cross your neighbor's land to get to the street. That's a right of way. That's a property interest. Of course, it's not a life estate because it's not exclusive possession for your life. It's just a right to cross the land, right? Usually for a specific purpose. And that is a property interest. It's not a license because it's not, right, time limited. It's indefinite in time. You have a right to cross forever. It's registered usually, but not necessarily with the land registry. That's a right that counts as a property interest for that person. Usually for that reason it will be sold for money. And again, that's a thing that you can do as the owner of the land, right? With fee simple, you can dismantle your rights in the bundle. You can give away a life estate, you can give away a leasehold estate, or you can also give away other kinds of property interests which we haven't seen, such as a right-of-way. The other thing you can do is mortgage your land, which is not something we'll look at in a lot of detail. But a mortgage is a security interest. It is an action by which you pledge your stuff as collateral, right, as a security, in the case that you don't pay, to a third party. So you want the bank to give you a lot of money. The bank won't give you a lot of money because there's a big likelihood that you won't pay. and you don't have $1 million in the bank that they can seize in case you don't pay. So what will the bank do? The bank will say, we will take your house as collateral. We will use the house as a guarantee. It's still your house, but there's a contractual provision that says if you don't pay, we get to take the house, to simplify things. That's a security interest because the house is there as a security. It's there to protect the bank against the risk of you not paying. And that is not a transfer of a property interest because there's nothing that happens in the present. So when you pledge your house, right, you still own it. You own it entirely, even though you bought it with the bank's money. The bank only gets ownership, or in fact, any title of any kind to the house, which will be full ownership eventually, so fee simple, right? Once they seize it properly with the legal process and all that, right? But the bank, at the time you pledge it, does not have, right, a property right in the house. You own the entire house even though you haven't paid your mortgage. That's what we call a security interest. That's another thing that you can do by virtue of your fee simple. So, creation of a fee simple, page 224, right? Again, there's only one formula. The magic words to A-N is Ayers. Two portions there. 2A, or the words of purchase, meaning, in a very confusing way, transfer. And again, as we said in previous weeks, there is absolutely no requirement that you get money for stuff, right? Usually people give possession of their stuff away in exchange for money. Otherwise, they keep it, right? Usually you need an incentive to do that. It doesn't mean that it has to be the case, right? You can lend your personal or real property, so your house or your bike, whatever it is, right, to someone for free. And that's fine, and you can do that contractually. You can give away your house if you're feeling generous. So to A are the words of purchase, but purchase doesn't mean it has to be for money. It just means transfer. So again, it's just a transfer of all the kinds possible you can do when you are someone who holds a fee simple. Namely, again, right, for free, for money, when you die, while you're alive, right, you can transfer it whichever way you want. And even, right, as we said, in whole or in part. And is heirs are the words of limitation. Again, limitation being very confusing because it doesn't imply a limitation at all. In fact, it simply delineates the nature of the estate that is given. However, a fee simple is contrasted to a life estate is not a limited interest. As we said, it is the most significant and expansive interest known to the law. And therefore, even though they're called words of limitation, that only means that they serve to delineate, to define the nature of the interest that is transferred. It doesn't mean that transfer is subject to a condition or a limitation. And more specifically, and quite importantly, as we said in the previous capsule, to is heirs in literally means nothing. It just means you have a fee simple. It's just the magic words that the people in England decided had to be used a couple hundred years ago. It means nothing. It doesn't mean that it has to go to your heirs. It doesn't mean that you have to have heirs. It doesn't mean that your heirs have any right. So if you decide to give away your house to charity, you have the house in fee simple, your heirs cannot show up, whether you do that again while you're alive or not, by will or by deed, right? The heirs don't get to show up and say, hey, we've got a right because it says to A and his heirs, therefore, if they transfer it, we won't get anything. It doesn't work that way. Heirs means nothing. It just means A has what you've been mistaken so far as full ownership. And as you can imagine, full ownership does not imply that you have to ask your kids for permission. So the heirs, right, first it means nothing. Second, by virtue of that, they have no right, neither present nor future. Right? It's just a coincidence if the quote-unquote owner decides to give it to their kids by will. It's just their decision. They might as well have given it to charity, right? or to anyone else, it's fully fortuitous. It's not by virtue of the words that have been used in the transfer document by which A acquired the right in the first place. Okay, so why did I say the magic words aren't that important anymore? It's still 224, because there is a statute in Ontario since 1990, which says that there's a presumption that you are transferring in fee simple. Why is that? Because no one gives life estates anymore. And when they're trying to do that, because it was a thing for women who couldn't work to get the use of a house in one way or another for the rest of their life, because otherwise they couldn't pay for it. And then when they died, usually the value of the house you would give away to your male kid, because your male kid was the only person that mattered, because your female kid first couldn't own property by law even if they tried, so it just wasn't a thing. And also because they got married to another male kid who got their own house, and so it didn't really matter. That's the historical reason. As you can imagine, it's not applicable today. Therefore, people don't use life estates anymore. And if they want to use life estates or something similar, where essentially someone gets something for a period of time, they'll use what we call a trust, and which we'll look at in more detail. A trust is an instrument by which you put stuff away in an imaginary thing that's managed by a third party that we call a trustee for the benefit of someone. So you've got $5 million. Your kid is irresponsible. You die. Before you die, you think if you give your kid $5 million, he's going to buy Ferraris. And you don't want them to do that. So you still want them to have the $5 million. You just don't want them to buy Ferraris with it. What do? You put it in trust. You create a trust. We'll call it the Phil Trust. You put your stuff in there. Again, now your stuff is in the imaginary thing. Your $5 million in the imaginary thing. Managed by a trustee. We'll call them responsible person. Responsible person manages the money for the benefit of the irresponsible kid. And so if the irresponsible kid can't eat, the trustee will give them money so that they can buy food, but will ensure that they don't give sufficient money such that the kid will buy Ferraris. And therefore, the trustee does not have an interest. They can't use the $5 million for their own benefit, of course, because that's not their job. Their job is to manage it for the benefit of a third party, namely irresponsible kid, And so, and in fact, if the trustee uses it for their own benefit, that's fraud, essentially. So the trustee is going to manage it for the benefit of a third party, but is going to retain sufficient control over the money such that the third party doesn't use the funds irresponsibly. Normally today, if you're trying to have an interest for a person's life, that does not imply that they get the rest of the stuff. You see the similarities there, So if you give a life estate to someone, irresponsible kid, then they have the house for their life. When they die, they don't have the value of the house. Same thing as the $5 million, For the period that the trust exists, they get some of the money, but they don't get the capital, the $5 million that you didn't want them to have in the first place because they're not responsible. Same thing. So usually, life estates today would be in the form of a trust. For that reason, Again, the fee tail is illegal because it's discriminatory. It's the first freehold estate. There's three. Second one is life estate. Life estate is very rare because now women work, and because usually if you want to replicate what a life estate does, it would make more sense to do it with a trust. Therefore, the only thing left really, sorry, this is my third finger, happens to be the middle finger, the third interest would be, the fee simple. So it's really the only freehold estate that matters today, It's still important for you to understand the life estate because the exercises are going to be on that, and because it's helpful when you practice law to understand where this comes from, but the only freehold estate that really matters is the fee simple. And then the other things we have are leasehold estates. So by default, the assumption would be, if people are transferring something, it's going to be clear it's either a lease, or if it's not, it's 99% going to be a fee simple. For that reason, the smart people in the legislature of Ontario passed a law which you have at page 224, the Conveyancing and Law of Property Act, which says there is a presumption that it's a fee simple. So you don't have to use the magic words for a fee simple. For the other stuff you do. So you don't have to say to A and his heirs. If you say something, if you say that poorly, it's still going to be, unless the court is sure that it's something else. It's a presumption. So it's going to be, unless the court is sure that it's something else, a fee simple. If you say nothing, it's going to be a fee simple. Unless the court is convinced it's something else. But if it says nothing, right, there's no presumption would ostensibly apply. So the law says it is a fee simple even if you don't use the magic words. However, there's a date on there, subsection 5.5, which gives you a date. It means that before that date, you had to use the magic words. The statute doesn't apply. That's the important stuff. Okay, second thing we talked about is the life estate. As we said, it's more limited. Therefore, the owner, the person who has a fee simple, retains an interest, which is, as we said, the right of reversion, which is the right to get possession back when the estate's over. Similar to a leasehold estate. When the lease ends, you get to show up and take the house back. Life estate, when a person dies, you get to show up, take the house back. Or whatever the thing was, the land, right? It is not a leasehold interest, importantly. It's a life estate. So, and that changes the things because a life estate is, as we said, a freehold estate, not a leasehold estate, which essentially means that the person has more extensive rights, notably the right to get the land back, as we said. Not all that important, but we mentioned that already, right? So it is a freehold estate, like a fee simple is, and unlike a leasehold estate. So leasehold estates is going to, that's how you make the difference. It's going to have a date on it. It's going to say this is a lease for 10 years, or 1 year, whatever it is. You get possession for that period. That's a leasehold estate. If it says for life, then it's a freehold estate, as is a fee simple, in the form of a life estate, right? And therefore, the rights that attach to it are slightly different. Okay, so the right to get the house back. We said so far it's called a right of reversion. I think you got that, right? It's the right to get possession back when the life estate's over. In fact, it's got two names. It's also called a remainder interest. And that is when it is held by a third party. So it's the exact same thing. Regardless of who owns it, what they get is the right to show up and take the house back. However, if it's the person who granted it, so someone, right, signs a piece of paper that says, I am granting my land to A for life. The person who transferred it, we call them O so far. O has a right of reversion. If, by virtue of the same document, say, O transfers that right to a third party, which we said they can do, says to A for life, then to B and his heirs. B is not O, is not the person who granted it. They are a third party. Then the name changes. It's called a remainder interest. Other situation where that can happen. So the example I just gave you was in the transfer document. When giving rights to A, there was a provision that gave the rest of the rights to a third party, as opposed to the O, the person transferring it, keeping it. Other option is, the transfer document just says to A for life, gives A a life estate. Subsequently, O decides to give or sell their right to show up when A dies to someone else, which they can do again because it's a property interest, And you can transfer property interest, right? When you've got it, you can transfer it. And because it's a bundle of rights, right, that includes a subset of your rights, namely your right of reversion, which is to show up when the person dies. So you can transfer that. You don't have to transfer it when you give a life estate. You can do that later. That's allowed for the reason I just mentioned. And that's the other situation where it's now held by a third party, namely someone else, right? And then it's called a remainder interest. It's the same thing. You get to show up, take the house back. It just has a different word for it. And this is similar to, right, the trusting. Because a life tenant, who again, I didn't make up the words, who again is not a tenant, because they have a freehold estate, right? You can rewind me if you didn't get that. They have a freehold estate, not a leasehold estate. Nonetheless, the judges call them a life tenant. So the person who has a life estate, whom we misleadingly call the life tenant, this person, right, has a right to the income of the property while they are alive. Why is that? Because they have an essentially absolute right to possession. Because when you give someone a life estate, again, the magic words are 2A for life. It doesn't say 2A for life as long as they personally occupy the property. So A can decide to either not use it, and they still have their interest. It doesn't vanish, right? Unless someone shows up, gets it by adverse possession, right? As we discussed last week. So they have it. They don't have to occupy the property themselves. What's the other thing they can do? They can lease it, and they can do that, right? They have a right to possession for the duration of their life. That's worth something. And it's worth something to someone else who's going to pay for it. And they can do that. They have a right to possession for their life. It's not a right to possession limited to themselves. Therefore, they can essentially lease the property to someone else and keep the money. Because they have that right. They have that right to possession, whether they exercise possession themselves or by virtue of a third party. And that's allowed. In that sense, it's similar to a trust. Because for life, you have an income interest. Namely, you can occupy the property yourself, or you can lease it, in which case you get the money. When you die, the owner has what they call a capital interest, which is the house. It's the investment. So the life tenant, again, misleadingly, person who has a life estate, while they are alive, get possession, or the rent from possession. They don't get the house. They just get the house for life. What's that mean? The other person, or the third party, gets the house back when they die. Therefore, they have a capital interest, right? If you don't get that, it's not that important. I mean, the use of the word. They have a capital interest, which is the house, the investment. So, life tenant gets the income from the house. It's an income interest. Remainder person or right of reversion gets the actual house, which is a capital interest, which is the thing. Same thing for a trust, right? You've got my $5 million example. That's put in trust, right? What's the purpose of that, right? The purpose of that is that the money earned from the $5 million, the trustee will give to irresponsible kid. However, the $5 million, if it's managed properly, stays intact. It's how charities are run, right? They've got a big pile of money, and they just spend the interest. That's why they can exist forever. That's the idea. The income interest is essentially to irresponsible kid. And then the trustee will decide, the person created the trust, dad, right, or me, will decide what they do with the $5 million afterwards, right? They might say, well, then when I die, when my kid dies, they won't need the $5 million, I'll give it to charity. And that's the capital interest. So you want irresponsible kid to have the income from the property, which is the cash, for their life, and then you want a third party to have the capital. It's essentially the same thing. Cool stuff, eh? Right? So as we said in the previous capsule, right of reversion or remainder interest if it changes its name. again, which doesn't change the nature of the underlying legal interest, that is a present interest, as we said. It is a present interest because it is certain. It is certain that one day the life tenant, A, the person who has a life estate, will die. And that makes it a present interest because it is certain. It is uncertain as to when, as we said, but it is certain as to the fact that it will happen. That makes it certain, that makes it a present interest. So A, or O, whoever it is, the third party or the person who gave it away, say it's O. O has a present right to enter the property in the future. It's not what we call contingent. Contingent would mean it's conditional, and that would imply that it's not certain. In contrast, the fact that people die is a certainty. They do die at some point. So it's a present interest to future possession. That, as we said in the previous capsule, will become important because there are rules as to how long you can have a potential interest for. If there's a condition and you don't know for sure that it will be met, there's a time period that limits it. And we'll see that later. A corollary of that, because they have a present interest, O can prevent A from messing up, which just makes sense. So O, again, person has a fee simple. They have a house. Then they give a life estate to A. So they give the possession of their house to A for his life. A has exclusive possession. So if O shows up, A can call the police and kick them out because they have a right to exclusive possession for the duration of their life. That might mean that A might do something irresponsible, like burn down the house, or not take care of it such that it's worthless when they die. That would not be fair to O, because O has, for the reasons we mentioned, and again, the beauty of this is that you can rewind me, right, as we said, has a capital interest. An interest to get the value of the house when A dies, because the house is still theirs, subject to A's exclusive possession for life. So we allow O to force A to make sure not to mess up the value of their investment, which is common sense for the reasons I mentioned. And in fact, it's also common sense by virtue of what I just said. They have a present interest to future possession. And that is why, right, which is really an interest to have the house, right? It's still their house, subject to A occupying it for their life, right? That's a present interest. Present interest means that now, even if they only have possession later, now they can force O to take correct care of it. So they can sue O and sue A and say, right? Again, O is, I might have misspoken there, right? A has a life estate. They can sue, O can sue A to take reasonable care of it. They can say, although you have exclusive possession, I want you to give me a right next Tuesday to show up and make sure the house is not in disrepair. Or, right, if A does make it, does lead it to a state of disrepair or burns it down, they can sue A because A has violated the right to O, to the capital, has affected the value of the right that O retained, and therefore that is extra contractual liability, something you can be sued for. As a corollary of that, the expenses are also shared proportionately. So, if it's a current expense, get light bulbs. As in a lease, right, you'd expect the person who has possession to pay for that. If it's a capital expense, like getting a new roof, that you don't expect the person who has possession for life to pay for, because it's a capital expense. It serves to maintain the value of the house so that when they die, the thing that reverts to O is not worthless. And again, could be O, could be a third party that O has granted it to. That is regulated by what we call the law of waste. Waste is just, again, a word that some judge thought was fit because it developed as a common law tort, right? 100 years ago in England, right, the king didn't pass a law on that, so the judges had to make it up. And you've got three types of waste. They are mentioned at page 226. But all of them are examples of the same thing. The life tenant, A, who has a life estate, does something that affects the value of the thing itself, the house or the land, and therefore prejudices the rights of the person who has a right to get the house back eventually. Voluntary waste is when you're neglectful, when you don't take care of the house. Permissive waste is when, voluntary waste is, we'll take them in order. Permissive waste is when you're neglectful, when you don't take care of it, and therefore it falls into a state of disrepair. Voluntary waste is when you do it purposely, right? So you burn it down, you take a hammer and punch the walls, whatever it is, right? Ameliorative waste is when you do something you don't have to do, which is get a new roof. That is still waste in the sense that it affects the value of the person who has the right to get it back. However, generally it wouldn't work, right? First, they wouldn't sue because they're really happy they just got a free roof, right? And if they sue, it's extra-contractual liability, so you've got to show the usual stuff, right? Harm, causation, right? Well, you don't show harm, of course, if you made money. It's the opposite of harm, therefore it wouldn't work. Nonetheless, it's a type of waste. Fourth type is equitable waste. Equitable meaning, as we said, not legal. So back in the days, right, you had two courts. You had a court of law, where you went if your rights were infringed. And you had a court of equity, which was a place where you would go and say, it ain't fair, right? It was a court of justice. It was where you went when your rights hadn't been infringed, but you thought it wasn't fair, so you wanted the king to make it up and grant what we called equitable relief. So, equitable waste is when you have no right to waste. How can that happen? Well, you can put it in a contract. You can say to A for life, give them a life estate, you retain the right of reversion. But you put in the contract, I cannot be sued by A pursuant to the law of waste. And then, right, it would be really dumb to have that provision, obviously. Nonetheless, right, you put that in there. Well, then if A burns the house down or takes a hammer and punches the walls, you can't sue them because you waived your right to do that. Pursuant to equitable waste, the courts are essentially going to say, if it's really bad, you can still sue. So if it's a big damage, then you can still sue. Okay. You can also have a life estate for the life of another. You have the spelling of that on page 228. For some reason, they didn't even get the French right. Anyway, that's what it is, right? That being incorrectly capitalized and incorrectly spelled French, for the life of another. So how does that happen, you ask? It happens first, naturally, because you can transfer a life estate. So O has fee simple. They got the whole thing. Transfers it to A in part as a life estate. A has a life estate. O retains right of reversion. Get the thing back when A dies. Then A transfers their life estate to B. Of course, they don't transfer the right of reversion because they don't have it, and you don't transfer something you don't have. They transfer their life estate to B. What happens there? Again, they transfer what they have, which is an estate for the duration of their, A's, life. When they transfer it to B, it doesn't magically become for B's life, because then they'd be transferring an interest that they don't have, which they can't do. So they transfer their interest for their own life. So B has a life estate, that's not what it's called, but for the life of A, in the sense that the duration of the life estate is A's life, not B. And that's what we call a life estate for the life of another. You can also have that by virtue of the granting document. You can say, I'm granting this to A for the life of B. No restriction on that, right? You can do that directly. The life that determines the duration of the life estate does not necessarily have to be the life of the person who gets it. In that example, importantly, A retains nothing because they transfer everything they have to B, which is a life estate for the life of A. The life of A is the maximum duration of the life estate. If B dies and A is still alive, they don't get the thing back because they transferred it. It's over. A life estate is for the life of A, so it's only relevant if A dies first. So B has it. They have a life estate for the life of A. When A dies, if B's not dead, it's over. That does not mean that if B dies, A gets it back. It's over. If B dies, it's over. If A dies, it's over regardless of whether B died. Note that down for a second, right? It's for the life of A. That means if A dies first, the life estate is over, even if B is not dead, because their life doesn't matter. However, a life estate also terminates upon the life of B. So if B dies, even if A is still alive, it's over. They don't give it to their kids, they don't give it back to A, it's over. Okay, then you have a bunch of cases not that important. They just give you a bunch of examples, right? Retailer case, page 229, right? Essentially what happens there, a bunch of permutations in the cases which can be interesting. Retailer, the guy gives a life estate. It's clearly a life estate because it says for their life, but then gives her additional rights to the capital. So they don't just give the usual thing, which is a life estate to the wife, then right of reversion to someone else, which means that the value of the house goes to someone else. He essentially says, oversimplifying the thing, right? If the wife runs out of money, she can also take money from the house. That would normally be part of the right of reversion. And the question is, can he do that? The answer is yes. She still has a life estate and something more. And that something more does not invalidate the life estate. That's what comes out of that case. It gets more tricky when it's potentially a license. A license is less than a life estate, as we said. It's not a property interest. It's the smallest thing you get. It's a concert ticket. It's paid toleration of you being somewhere where you normally don't have a right to be, usually once, usually in exchange for money, because that's why people tolerate your presence. Being invited to a barbecue, I think that's the example someone gave in class, same thing. Then it's free, because you're an enjoyable person to be with and they're willing to tolerate you for free. It's limited in time, right? It's for that night, then they kick you out. In my example, it's clear that it's not a license, because she didn't just get the life estate. She got the life estate and something more, so clearly it's meant to be at least a life estate. That gets more complicated when it's the opposite, when it seems to be less than a life estate. If it says, right, I'm giving you the house for life unless this thing happens, then it's less than a life estate, ostensibly. Before you learn the stuff on the future pages, I'm at 231, right? It's less than a life estate. So it might be a license, and that makes a big difference. Because a license is, for reasons you don't have to understand, it would mean that only her could occupy the house. It's not a right to universal possession of the house, which means she could rent it out. A license would mean she has to personally occupy the house. So then the issue becomes significant. If you say it's for her life except if, well, the except if limits a life estate. So then the question is, does she have less than a life estate? Can you have less than a life estate? And does that make it a life estate or with an additional condition, or does it simply make it a license? And that makes a big difference again, because you get far fewer rights. And the answer is essentially yes, it can be a life estate with a condition, and we'll learn what condition means shortly. That's at page 231 and following. Exercises at page 234 are important. Emily's going to go over them with you. So, we were, of course, missing an additional level of complexity. I told you this was going to be fun, right? So, the added level of complication is conditions. You can have conditions on an estate, whether it's a fee simple or a life estate. Okay. There are 3 types . Okay, so let's use an example. Again, this thing. A wants to give a life estate, O wants to give a life estate to A. But only if A goes to school, because otherwise they suck. Can O do that? Yes, they can. It will be subject to a condition. As you can imagine, conceptually, there can be 2 kinds of conditions. There can be what we call a condition precedent, which is a condition that you have to meet before you get the interest. So say A gets a life estate or a fee simple if they go to school. That's a condition precedent. They only get the life estate once, timeline there, right? Meet the condition before, then they get the life estate. Only get the life estate once they've gone to school. The other thing you can have is a condition subsequent, which is a condition through which you lose your rights. So, A will get a life estate unless they conceive illegitimate children. Right? Or until they conceive illegitimate children, or unless, right? Then it's condition subsequent. So they get the life estate. If they never conceive illegitimate children, they get it forever. If they do, it's taken away from them. That's a condition subsequent because in time, it happens at the end. It's the condition by which you lose your right as opposed to acquire it. Precedent means before you get it, right? So you have to meet the condition to get the right. Subsequent means it is after. So you lose your right by virtue of the condition. As we'll see, there are 2 ways to have a condition subsequent, and it matters a lot. The first one is what we call defeasible upon condition subsequent. That means the distinction between defeasible and determinable. Defeasible is, it's a possibility. So it's going to say, if she conceives illegitimate children, that's just an example, it could be any condition, right, unless it's against public order. I'm using illegitimate children because that's what it was used for in the first place, but it could be anything, right, if she ceases to farm, right, it could be anything. If, word is if she has illegitimate children, I may re-enter. Okay. That is what we call, okay, and this is in the book, my 235. My handwriting is going to be very, very bad there. Okay. It's called a right of reentry. So, okay, let's backtrack. If you give a life estate to someone else, period, it's a life estate. As the grantor, as the O, you retain a reversion, a right of reversion. Unless that right is given to a third party, as we said, before or after the granting, in which case it's the exact same thing, but it is called a remainder interest. These words work if it's a life estate, period. Now we have added an additional level of complication upon which we are giving a life estate or something else, could be a fee simple, with a condition. When there is a condition, we will use the words you're about to learn, not these words. These words are the words for a life estate. I'd rather be annoying than you not understanding this. These words are for a life estate, period. Not a fee simple, because if it's a fee simple, there's no reentry, right? There's no person showing up pursuant to a right of reversion, right? The grantee, A, has the entire thing, right? So first there has to be a life estate. Otherwise, the two rights are A's. So it has to be a life estate, and it has to be a life estate, period. If it's a life estate with a condition, then it's the words we're about to learn. So this is for a life estate without a condition only. If it's a life estate or a fee simple, because you can attach a condition to both, right? Or a fee tail for that matter, but as we said, that is no longer legal in Canada, so it's already that complicated enough. If it's got a condition, so whether it's a fee simple, which can have a condition, or a life estate, which can also have a condition, then we will use the words we're about to learn, not these words, which are for life estates without conditions. I think I've said it enough times now. So you can have three types of conditions, each of which is going to have its own magic words. Defeasible. It is called a right of reentry. Defeasible means you are using a conditional word. If she conceives illegitimate children, the operative word there is if. Unlike the other magic words we learned, like and is heirs, there is no single magic word that can be used. You can use multiple magic words. So you can use if, or you can use a synonym of if. So if you say in the event that, that's a synonym of if. So it is phrased as a possibility, not a certainty. And how we know that? We know that because you use the word if or a synonym. So it's going to say, if she conceives illegitimate children, I may re-enter. That's a good way because it uses the magic words, but you don't have to. Then the person who retains the interest has a right of re-entry only when it's defeasible. So if there is an if or a similar word, it is defeasible upon condition subsequent, right? Then the way it's phrased, she has the interest until and unless she conceives illegitimate children. That's why it's subsequent. It doesn't say once she conceives illegitimate children, she will get a life estate, in which case it would be precedent. So it's subsequent because she loses her interest, which she otherwise has if something happens. The something is conditional if she conceives illegitimate children. Therefore, it's defeasible, not determinable, and therefore, the interest of the other person, again, could be the owner or third party. So if the owner, O, grants her a life estate, but if she conceives illegitimate children, I may re-enter. O, I, retain, the owner retains a right of re-entry. They could give it away to someone else. Again, because you can give away whatever property right we have. Right of reentry is a property right. You can give it away. Same thing as what we said before. By the document or otherwise. So in the document you can say, if she conceives illegitimate children, B can reenter. Or you can do that later. You can, if she conceives illegitimate children, I may reenter. Then 2 years later, you give that away to B. So the third party or the O has a right of reentry. Other way you can have a condition subsequent is what we call determinable. A determinable life estate. What's the difference? It is phrased as a certainty. If is not a certainty. When is a certainty. When is when this happens. The assumption is when you say when this happens, is that it will happen. Otherwise you'd say if it happens. And because of that word, simply by virtue of that, it's determinable. That's the only difference. It can be the same thing. It can be when she conceives illegitimate children, right? I will have my right, which has a different name, right? Which is a reverter. Again, that's a special magic word. If it's a life estate, period, it's this. If it's a life estate with a condition, we've got different words. You have to decide if it's defeasible or determinable, and there's respective magic words. If it's determinable, it's a reverter. Same thing, just depends on how it's phrased. When she conceives illegitimate children, I may, right? I retain a possibility of reverter. It's the same thing. You get to show up and take it back, and it can be the same condition. The only thing is the word that's been used. And because of that, it doesn't mean that she's more likely to conceive illegitimate children because of the word you used. Right? So the word that you use is going to make all the difference. That's it. It's not the likelihood of the event. It's just a word. If you use if or a synonym, it's defeasible. If you use when or a synonym, something that conveys certainty. When, right? Or at the time that she. That also conveys certainty. If it's when or a synonym, it's determinable. And again, it's subsequent because she loses her right. So she has it in the first place, whether it's a life estate or a fee simple. And she loses it when she conceives illegitimate children. So why is the difference significant? First, it changes the magic word. So the right of the O, or the third party, the right of the other person, is going to have a different name first. Second, it's going to be slightly different in that if it's defeasible, it needs to be exercised. So, the granting document is going to say if, or something similar, she conceives illegitimate children. She does. When she does, it's still defeasible, right? The when does not change the granting document. The granting document is if. When she conceives illegitimate children, the grantor, O, does not automatically get the property right that she has back. They have to exercise it. So they have to realize that she's had illegitimate children. They have to show up, and then they have to say, now you got to leave because you've got illegitimate children. If she doesn't leave, right, they'll call the police or go to court. If they don't do that, they don't get it. Why is that important? It's important because it's then prescriptable. Because they have to do something, their right to do it can be extinguished pursuant to prescription. So if they do not show up and the limitation period runs, this is a property right, just like ownership was last week. You can lose ownership after 10 years. Well, you can lose some other property right or acquire some other property right, like a right of way for the same period, same thing there. You can lose your right of reentry after 10 years. So the lady, who then does not have a right to possession, would acquire it by virtue of acquisitive adverse possession, right, acquisitive prescription. After 10 years, they would get, right, either a life estate or full ownership. In contrast, and that's just because they used if. So you can imagine it's not a good idea to use if you're a lawyer. If it's determinable, it is automatic. So automatically, she loses her life estate. And this is just a conceptual difference. In the first example, she keeps a life estate she doesn't have a right to. So it says, if she conceives illegitimate children, I may re-enter. Until you do, she still has a life estate even if she has met the condition subsequent. She still has a valid life estate until you show up. If it's determinable, it's the opposite. She doesn't. So then she's in the house like an adverse possessor. She's in the house like someone who broke in and ended up there. So it's simpler for you to kick her out because she's there without a right. But at the end of the day, it's somewhat similar because if she stays for 10 years, she can still acquire some right by virtue of prescription. But conceptually it's different and it's automatic. And we'll see one of the ways in which that's important is that we'll see there are rules as to uncertainty, different from prescription. So if there's uncertainty as to when he re-enters, it's not just the statute of limitations that apply, it's something else. That because we don't like things to be uncertain and contingent. And in that case, it's not uncertain. Here it is, because she has a life estate with the illegitimate children until they show up. Until O shows up. So it's uncertain. They might never show up. They might show up 10 years from now, 20 years from now, who knows? If it's determinable, we know it's happened. As soon as she had the kids, she lost her life estate and she's in there like a thief. Right? Like someone who broke in. And that's going to be important when we learn the rules about uncertainty. Whew. These are both conditions subsequent in that, again, they have the person lose their right. Whatever it is. Life estate or a fee simple. Again, subject to a condition. If there's no condition, life estate is this. If it's a fee simple, it's just absolute. You can also have a condition precedent. Precedent meaning it's before. Right? So before means before. They do not acquire their right unless a condition is met. Then it's a condition precedent. So they acquire the right by meeting the condition as opposed to losing it. So A will get a life estate if they finish law school. And that's going to be an interest that is contingent and uncertain. Because unlike a life estate or a fee simple, it's not sure. It will happen. So we said a life estate is certain because it's certain a person will die, but not when. This is different because it's not certain at all. The person might finish law school, they might not. In contrast, they will die. Regardless of when, they will die. And we'll see again, that becomes important because it's subject to the rules, as I suggested earlier, on uncertainty, because there's a limited period for which uncertainty can run. Okay. The other reason, okay, so, and this is not just uncertain, it is not a present interest because it hasn't happened yet. So we said life estate is a present interest, and the thing retained by the O, the grantor, is also present because it's certain. It's certain that they will get a right to show up and take the house back. It's not sure when, but it's sure that they will. Therefore, a reversion, a right of reversion, or a remainder, which is the same thing in the hands of a third party, right, is a present interest because it's certain. In contrast, when something is subject to a condition precedent, it is a future interest because it is not certain yet. Not only is it uncertain as to timing, it's uncertain as to happening. The kid might never finish law school. Therefore, we can't say he has a right because we don't know if he will. He might never have that right because he has to meet a condition to get it, and that condition might never be met. Therefore, it is not a present interest. And again, this is going to be important when we start learning about uncertainty. I suggested that earlier. I'm at 236, if that's helpful now. All property interests can be transferred. You can transfer the bundle of rights. You can transfer a subset of. So you can give someone a life estate. You retain a possibility of a right of reversion. You can transfer that to someone else. You can transfer a right of way. You can transfer a profit of progeny. Anything that's a property interest, you can transfer, sell. So all these things, which all have different names, they are property rights. They count. Therefore, they can be sold. Might not be worth much money, right? If it's a possibility that she has an illegitimate child, it might not be worth a lot of money because it's unlikely to happen, say, right? Nonetheless, it can be transferred freely because it's a property right. All that, everything, all the names we use can be transferred. Case page 237, Reed Tilbury West Public School. What happens there? Essentially, because this is getting really long, I'm sure, essentially it ain't clear if it's defeasible or determinable because the guy didn't hire a good lawyer. So the guy said something that sounds like if, in which case it's defeasible, and said something that sounds like when, in which case it's determinable. And one thing we haven't covered so far, another reason why the distinction is important is for validity. If it's determinable, because we are sure that it will happen by virtue of the word you used. Again, it might never happen, but the word conveys a certainty. When conveys a certainty as to the fact that she'll have illegitimate children. It might be wrong, in which case she'll have a fee simple, right? The equivalent of a fee simple, or a life estate, because she'll never lose it. But the word conveys certainty. For that reason, it is part of the interest. So if it's determinable, we'll call it whole. It's together. The condition is part of the interest. So she has, until she conceives an illegitimate child, that means if the condition's invalid. So say you go to court and you say this is outrageous because it's discrimination against the kids, therefore this condition is invalid. If the court agrees with you, the entire interest that she got, fee simple or life estate, subject to a condition subsequent, the entire thing is invalid because it's an integral part of the interest. Because, again, you use a word that conveyed certainty. Because you used when. If the condition's invalid, the interest also is because it's a thing. If it's defeasible, it's not. So the condition can be independently invalid. Republic school, guy hires a bad lawyer, as I said, uses something that sounds like if, something that sounds like when. What happens? Well, the court says, right, he looks at the words that he used first, right? So he says, for so long as it shall be used for school purposes and no longer. That suggests certainty. That sounds like when, right? Sorry, sounds like the opposite, right? So long as used for school purposes. That sounds like when. And then he uses except when no longer used. And that sounds like if. And the court, right, is essentially going to look at the first characterization, or the one that seems like the main one. The takeaway is, right, you should use if or when and a clear synonym of that, and certainly you shouldn't use both something like if and something like when in the same granting document. And because he used, right, something like when as the main direction, it is determinable. Then you have the Remy Coughlin case, which is the opposite of what we saw. So we saw an example where someone is granted a life estate, right? And then that life estate, she gets something more. She gets a right to essentially get money from the house to the extent that, right, she needs it. And otherwise, that would be the interest of the person who has the reversion. In the Remy Coughlin case, 239, you have the opposite situation. You have a life estate, but she also loses it if there's a condition. Does that make it a license? No, we just learned why. Why? Because you can have conditions which essentially limit the extent of a life estate. Normally a life estate is plenary, as we said. You can be there. If you don't want to be there for your life, you can rent it out and keep the money. If you have to be there personally, then it's a license, as we said. If it's a life estate, you don't. What if it's a life estate with a condition? The condition doesn't make it a license, of course, because we just learned that you can have conditions on either a life estate or a fee simple. And that's what happens there. And a court finds that, right, that does not make it a license. The fact that she has a more limited life estate, right, does not make it a license. And the court looks at, right, again, the general intention of the document to try to find the intent of the grantor. And that will be it for this week.